welcome back to Litigation Help. My name is Helena Birt, and today our regular guest, Helena Birt, is back with us to talk about costs in family law proceedings. Please note, though, that our information is based on Ontario, Canada, and it's just legal information. It's not legal advice. If you want legal advice, please consult with a lawyer. Welcome back, Helena.
Heather, it's good to see you.
It's been a while.
It has. My brains are a little rusty. It's going to be fun getting back up to speed again.
Yeah. Helena, can I just first start us off with just the very, very basic? What exactly do we mean when we say the word costs? What is that?
Okay, there are two different costs things you could be talking about in family law, but I know what you want to do today, so we're only going to be focusing on one.
Okay.
So the one that we're not focusing on is the issue of costs, which means that just if you're going to be a litigant in a family law case, you are sometimes going to have to pay for an expert or professional to do a report or to do an investigation or to do an analysis or something like that. So you have the issue of the costs of these kind of disbursements where you have to pay somebody else to do something.
Mm-hmm.
But those are just like when you're going shopping, you have to buy something, you pay for it. Those are costs.
Mm-hmm.
That's not what we're going to be talking about today, although it could become part of what we're talking about today. Because what we're talking about today is the issue of costs, which is basically, to go back to basics, the primary objective of the family law rules is to promote, and I'm quoting here, the expeditious and just settlement of family law disputes. So the rules, the family law rules, encourage parties to meet their obligation to make all the full disclosure relating to a case as soon as possible and to make every effort to settle.
Helena, what are
So
you quoting
that's
from? Sorry, if you could say you're going to quote, then we kind of have to know the source.
okay. That is okay. Where I'm quoting from is actually I cribbed this directly from the bar admission materials
Oh, okay.
published by the Law Society for
Okay.
the 2023 law exams.
Okay.
So it basically, a lot of what we're going to do today is go through the basic concepts. So yes,
Okay.
this is a quote from their rules, but it's even set out in the primary of, like in the family law rules itself, Rule 24, sets out the main objective is to promote expeditious and just settlement of family law disputes.
Okay.
So the whole issue of costs that we're talking about today is saying if somebody is not participating in a way that is fair, that advances the case, that means the person is meeting their obligations under the rules, there's a possibility that the court will issue a sanction against them in the way of saying, guess what? You have to pay the other side costs because you were supposed to do something and you didn't do it. Or you made, or this other person had to bring you into court on an interim motion or something to get something done because you wouldn't consent to something that was reasonable and you should have consented to without them having to bring the motion. You didn't do it. So in that case, then you're going to have to pay costs. Or it can even be to the point where you have two people that have very honestly held feelings about if they're going into court, like say on a temporary motion. Each of them is saying, I should have a child living with me on a day-to-day basis, not with the other person. And there are valid reasons and arguments that could support both sides' positions. But if they cannot resolve it and settle it, and they're putting it before a judge to make a decision, then the judge will still look at it and make a decision as to saying, I'm making a decision in favor of this parent, or I'm making a decision in favor of that parent. And once a decision is made, you've got a successful party and a not successful party. And as soon as that triggers, then the successful party can say, or especially if they've made an offer to settle and the judge has made an order that is as good or better than what they'd offered to settle for, so they never would have had to do this in front of the judge in the first place, then the successful party is entitled to ask for costs. So what it's meant to be is like the stick hanging over a litigant's head to say, if you do something that is not helpful to advancing the case, or if you're not following the rules, or if you're doing something you're not supposed to do, or if you're taking an unreasonable position, you can be made to pay the other party money for wasting their time and the court's time. And always the bottom line is saying, always both parties should be trying to settle things whenever they can. If they can't and it has to go to court, somebody's going to be a winner, somebody's going to be a loser, and the court will then have to decide if one party should have to pay the other money for making the party do something they shouldn't have had to do in the first place. Or even if they had to do it in the first place, they were the successful party. The winner wins. The winner can then make a claim for costs.
Now, when you
Does that
say
make
cost,
sense?
is it just basically the like the legal fees, the fees that have been paid to a lawyer, or is there more?
Costs are just, okay, there's especially, well, usually what you find is that if you have a party that has a lawyer,
Yeah,
there is a tendency, if a party has a lawyer and they're successful on
yeah,
getting an order for costs against the other side,
yeah,
then what those costs are going to be comprised of
yeah,
is they'll look at what the lawyer actually charged and
right,
how much did the client person have to pay out of their pocket to their lawyer to get
right,
to that point. What
right,
disbursements did they have to pay? What
right.
had to be done? One of the other myths that is out there is that I've run into a lot of self-represented litigants that say, well, I don't have a lawyer, so I can't ask for costs. But
Right.
that's not true.
Mm,
Because even as a self-represented litigant, you may have had to take time off work to come to court or to attend the Zoom hearing.
right.
You'll have spent a lot of your own time, and your time is worth money as well. Not probably as much as a lawyer you're paying on the Family Law Matter Act for you, but your time is still worth money as well. You've had to put money and time as an investment into getting this thing before a judge. And
Mm-hmm.
if you've done everything properly and done it right, and the other side hasn't, then you, as a self-represented litigant, are entitled to say to the judge, Your Honor, this person has just wasted my time and the court's time. They should be sanctioned with an order for costs. Because what it does is the other side is it makes a party that's not doing what they should be doing or that's being unreasonable, makes them think twice because they could be looking at having a court order money against them. They can't just sit back and try to stall or not do what they're supposed to do and expect to get away scot-free. There are things the court can do to them. Costs are only one of those sanctions. There are a number of different things a court can do to somebody that doesn't follow the rules, but that's a discussion for another day.
Right.
But
No.
that's
Yeah.
why I do say that to self-represented litigants at
Mhm.
every stage of a proceeding, if you're doing this on your own, but you've done what you're supposed to do and you're prepared and you're ready to go,
Mhm.
and the other side either hasn't done anything they're supposed to do or they're
Mhm.
not prepared or they're being unreasonable in what they're asking for, I always advise people to mention that to the judge and bring it up once the matter, where what the judge's decision is or what happened that day, then saying, Your Honor, I was a successful party today. I'm asking Your Honor to make an order for costs. Now,
Was
costs are always in the discretion of the judge.
Mhm.
Judge may order them, the judge may not. If the judge does order them, then it's a question of how much costs will the judge order. Which again brings us then to the second myth, which is that if you, let's say at the end of a trial, you have won on every issue that went before the judge for trial. And let's say that you have paid a lawyer to do that.
Mhm.
And the judge says, you are the successful litigant. I'm going to make an order for costs in your favor.
Mhm.
People think what that means is they have to say, well, this is how much I paid my lawyer. So that's how much the other party has to pay me because I should be compensated for everything I paid my lawyer.
Mhm.
That is pretty much a unicorn. You don't see it happen very often. Full recovery costs are very, very rare. And we'll talk about this a little bit later when we go through like the golden rule, when you're talking about how you actually look at costs and how they work in a family law matter, is saying if a party has acted in bad faith and the court finds a party has acted in bad faith, then the court can immediately order costs against the other party that acted in bad faith, and it's full recovery. So if the successful person can have their lawyer do the bill of costs, or if they're self-represented litigant, do a complete bill of costs showing exactly what they're claiming in the way of costs and the grounds to support why they're asking for that is, then a judge but still it's very, very rare, say, right, you paid your lawyer $35,000 to do this matter. I'm going to make an order for costs against the unsuccessful party because they acted in bad faith for $35,000. That happens in less than, I would say, half of 1% of all cases. People think that's what they're going to get. If the judge says, nope, you're right, the other party is wrong, you had to pay your lawyer, you got costs, that means you're going to get all the money back you paid to your own lawyer. Usually doesn't work that way. Full recovery costs are very, very rare. They're usually only granted in cases where a person has acted in bad faith, and it's got to be,
Mm.
they've acted in really, really bad faith, and we'll talk about maybe what that means later. But generally what that means is you might get costs on a substantial indemnity, which means that you submit your bill of costs, and let's say it's for 100,000, the judge may find, based on the issues, whether there were offers to settle filed or anything else, I'm going to make an order for costs of 60,000, not 100,000. Or it could
Interesting.
even be you were the successful party, but I really think that you bullied the other side. And even though you won, the other party had legitimate reasons for taking the position they did. You've asked for $100,000 in costs. I'm going to order $25,000 in costs. It still has to be based on the facts and the submissions the parties make about costs. But don't go in, if you're the successful party, expecting to recover 100% of what it's paid you to pay your lawyer. Or if you're acting on your own and you're saying, well, I lost 8 hours of work to do this thing and I make $85 an hour, don't expect to get that full $85 an hour back.
Yeah.
So,
All right. Yeah. So now with that thought in mind, you were going to tell us a little bit about the relevant rules in the family law rules that kind of give us the foundation
there
for
is
understanding.
the rule on costs under the family
Okay.
law rules is Rule 24.
Oh, Rule
Okay,
24.
it basically sets out the whole code of in a family law case about how the whole issue of costs is going to play out. And this is probably going to get boring for some of the watchers, and I'm really sorry about this, but it goes through the steps that you have to go through, even if you're going through this process yourself, and it is actually logically set up. Now, again, a lot of this is going to sound very similar, and I think Heather, you and I had this discussion earlier because you've done a costs thing within the civil arena that's
right.
not family law.
Yeah.
The same basic common law rules apply. There's a couple of tweaks because it's family law, but a lot of the principles and concepts are the same. So a lot of this might sound familiar for somebody that's been through like a civil lawsuit that's not a family matter. But a lot of it is going through the same thing. But the first place you start when you want to know how costs work in a family law case in Ontario is you look at Rule 24. You will find if you start actually really digging deeply and looking into case law, because you're trying to find something that might be similar to your fact situation that you can use to help. There are a lot of civil cases that consider the same concepts and the things that a judge should be considering when they're making an order for costs. And they're the same in family law as they are in any other civil matter. So that's the one warning that we're giving before we start. You'll always start with Rule 24, but there's lots of supporting cases that come into that a judge can consider that are not based on a family law decision, because the concepts in civil claims for costs are very much the same as what they are for family law costs. Okay.
Okay.
So we're ready to go?
Yes.
So again, and I'm not even sure if I said this yet, but I guess then the other basics foundational rock that you have to think about is right 24 sub 1 of the family law rules creates a presumption. And it's a very simple presumption. It is presumed that a successful party is entitled to the costs of the step in the proceeding that they were successful in. It could be a motion, it could be enforcement, it can be entire case, it can be an appeal. But the basic presumption is that if you're the successful party, you're entitled to costs. Now, the exemption that comes into there is that the presumption doesn't apply under Rule 24.2 is if a party is a government agency or part. So for example, like a children's aid society or community and social services. That presumption doesn't apply because quite often they might be like community and social services could be involved in a matter, or the Children's Aid Society. And they may win, and they win quite often. But because they are government entities with the full power of the government and that whole budgetary structure behind them, it's like the state versus the individual. The presumption doesn't stand when you're dealing with a party who is an institutional litigant. So even though the Children's Aid Society may be successful in a case, i.e., let's say that they've apprehended a child and they're saying this child has to be taken into care, and at trial, it turns out this child can never go back to the parents, the child is going to be adopted out. So if it goes through a trial and the parents have lost because the child has been placed in society care and is put up for adoption, the society has won. But in that case, because they are an institutional litigant, they are the successful party, but the presumption does not apply. So the court very rarely orders costs against a Children's Aid Society. But there are cases where it's happened, but usually only where the Children's Aid Society has behaved really, really, really badly and done things they shouldn't do. But it's the same way then, again, even if you are a parent who's gone to court against a Children's Aid Society, and the society ends up winning whatever it is they're asking for an order for what is to be done with your child, and you fought and argued against it and you lose, Very rarely will a court order an individual to pay costs to an institutional litigant. So that's just the whole thing about how the presumption doesn't apply when you're dealing with government who's involved as one of the parties.
Interesting. Okay, that's good to know. Right.
Does that make sense against
Yep.
you?
Mhm.
Yeah, and it actually specifies in Rule 24.3, it specifically says that the court has discretion to award costs to or against a government agency party, whether the agency is successful or unsuccessful.
Right.
So again, it's just saying that normal presumption doesn't apply when you're dealing with a government agency.